In Chapter 2, I spent some time discussing this issue of married women and credit. And I thought it was worth it to do so because it highlights some of the main themes of the book. Basically, in the past, married women had difficulty obtaining loans and credit cards without their husband's permission. And for some, this is an obvious indication of the patriarchal and misogynistic nature of our law. I, however, think, again, this is a poor analysis. And in order to better understand this, you have to understand the doctrines that gave rise to these conditions in the first place. In the last few videos, I talked about the doctrine of necessaries. This was the doctrine whereby women could purchase goods on their husband's credit, and their husbands would be liable to pay creditors for those goods. This was also a means whereby women could avoid personal liability for their own debts. And obviously, this was a function of the obligation that men had within the law to provide for their wives financially. Now, when we come to the 1970s, where there's this debate about consumer finance, and there are activists who are trying to change this, understandably trying to change these laws, by the way, there's again this misanalysis. There's this push to try to portray the law as sexist and patriarchal, and there was almost never a discussion about how creditors were worried about recovering their debts. I point out, and I offer a citation to a case, as late as 1972, a female litigant, this was in New Jersey, a case known as Sillery versus Fagan, but a female litigant tried to get out of paying a hospital bill. It's a good case, by the way. I recommend reading it. It gives a good analysis of this common law doctrine that really set the stage for these conditions. But in the case, the court ultimately ruled against the female litigant. Nonetheless, the fact that women were bringing cases like this as late as the 1970s, this is a good indication that creditors had non-sexist reasons for being cautious in extending credit to married women. Obviously, there were potential obstacles to recovering those debts. I would also point out this wasn't just an issue with case law. There were statutes that codified the doctrine of necessaries, and most of these statutes were not gender neutral. They applied only as against husbands. So only husbands could be found liable. Now, as time went on, this did change. Many of these statutes, they started to make them mutual between husbands and wives in the 1970s, in the 1980s, and some as late as the 1990s. I would point out that Kentucky still has a doctrine of necessaries statute that codifies the doctrine. And under that statute, men are still only liable. It's only liability is only attaches to the husband. So again, there were good reasons for this. Now, when this was being debated, there was a report that was prepared, and I cited this in the book as well. This is the report of the Commission on National Consumer Finance, and I got this. This was December 1972. And I got this from the Nixon Presidential Library. You can go online and get this. But I was reading through this, and this was very interesting to me because while they're trying to push for the Equal Credit Opportunity Act, and there are a lot of debates about this issue, they were sharing testimonials from women who were married women who were having a hard time getting credit. And I want to read one of those testimonials because I think, again, it highlights these issues that I'm trying to drive home. But it says, shortly after my marriage, I wrote all the stores where I had charge accounts and requested new credit cards with my new name and address. That's all that had changed. My name and address. Otherwise, I maintained the same credit rating, the same job, the same salary. The response of the stores was swift. One store closed my account immediately. All of them sent me application forms to open a new account, forms that asked for my husband's name, my husband's bank, my husband's employer. There was no longer any interest in me, my job, my bank, or my ability to pay my own bills. Well, why is that? Were these creditors sexist before or just after she got married, but not before she got married? Obviously, it makes no sense. And obviously, the whole point of this was they knew that once she got married, there were potential legal obstacles to collecting that debt. And it's so important to acknowledge this because when we try to paint our law as being unfair to women, we then seek solutions based on that misdiagnosis. That leads us into all kinds of bad areas when it comes to policy. So again, I urge people to look at this stuff to try to have a better understanding of the law, try to have a better understanding of the philosophy and the reasoning behind it. And I think when we do this, we find that a lot of these laws were not rooted in any kind of misogyny or patriarchy or sexism. There were a lot of other practical considerations that we just need to understand if we want to understand why and how the law functioned as it did and how it functions in the present as well.